everyone, welcome back to the channel. My name is Varun and I am a legal intern at LEXIS and Company. Today I am going to discuss about pigeonhole theory. The aim of this video to give the research regarding the pigeonhole theory. So here, if we put 3 pigeons in 2 pigeonholes, at slightest 2 of the pigeons put a stop to up in the constant puncture, then we can find that so far underlying attitude of life as it captures the self-same essence of counting. This paper also discussing how this theory evaluate in law with different examples. To analyze this theory, I have read many cases and journals. This theory is from various resources, case laws, and it is explorative in nature. Is it law of tort or law of torts? This question faced by every law of student in their first or second semester of law school. Regarding this theory, Solomon gave his view. What should be called law of torts, or we should call law of tort? To figure out this problem, Salmon introduced this theory, pigeonhole theory, and said it's not law of tort, it is law of torts. According to the statement, a person is liable for a tort committed by him, but there are some specific exceptions. When a person is made liable for tort which was committed by another, and the liability is fixed. Strict liability and absolute liability are well recognized for these kind of wrongful act. An act said to be tort when any harm-causing injurious act. A person can only escape from being guilty if that person can prove a legal justification for not committing an offense or an excuse to it. This video covers the main concept of tortious liability and the various theories of Winfield and Salmon on addressing tortious liability. So their definitions of tort can be summarized as follows. This introduced by Salmon, which can justify tort as any harm constituted as legal injury, must fit into pigeonholes that is specific tort because there is no space for another tort. Tort is a civil wrong. In cases of tort, their remedy is a common law action for an unliquidated damages, and which is not exclusively the breach of a contract or the breach of a trust or other merely equitable obligation. Tort is equals to civil wrongs. That is breach of trust plus breach of contract plus other merely equitable obligations. Winfield utility theory talks about liability of torts arises from breach of duty, primarily which is fixed by law. This duty is towards persons generally, and its breach is redressable by an action of unliquidated damages. It provides deterrence with kind of relief for diverse forms of harms like mental illness, financial injuries, and impairment of reputation or goodwill. This highlights the regulation of liability relating to the scope of tort, such as trespass to property, wrongful birth, and an unjust life. Tort is equals to breach of duty, remedy is equals to unliquidated damages. Fraser believed that an infringement of a right in rem of a private individual giving a right of compensation at the suit of the injured party. Tort is equals to infringement of a private right of individual's remedy, and that is equals to compensation. A person who violates duty and infringes the private rights of another is liable for committing the wrongful act. Such kind of liability called tortious liability. The liability which does not arise from any contract or other obligations and act of parties, but merely due to the breach of duty or trust, is known as tortious liability. This theory is completely different from criminal liability. So is it law of tort or law of torts? This question can be answered by the theories of Winfield and Salmon. So what is the Salmon's pigeonhole theory? Salmon believed that it is law of torts, not law of tort. According to him, there is no single principle to check the tortious liability. If any affected person can put the tort under any specified tort, that means if a person is entitled to file a suit against only the harm when it comes within one of the categories of this law. Specific verse like forgery, murder, etc. has specific torts, and all other wrongs fall outside of this preview, he could be eligible for damages. Otherwise, there is no wrong and remedy. So the burden of proof is vested on the injured party to establish that the tort is under any particular head or whole of specified torts. This theory is popularly known as pigeonhole theory. Torts like defamation, nuisance, negligence, trespass, etc. are examples of already existing pigeonholes. If the injury cannot be placed under any heads, it should not be considered as a tort and therefore cause the right of action. So now what is the Winfield's theory? If we look at the definition which is given by the Winfield, failed to distinguish between crime, tort, breach or contract. He believed that it is law of tort, according to him, where the legal injury is strictly against the recognized law of the land, or the general principle of liability arises when a person inflict injury to another, and or if a person violates the duty and resulted in the legal injury of other person, which says all unjustified harms are tortious. Then we can call tort, and the aggrieved party has a right of action for an unliquidated damages. Winfield leaves space for the creation of new torts. His theory has a wide approach towards tortious liability. New torts originated with changing times can be properly handled by Winfield's theory. Thereby, by extent of torts covered and range of remedy is also wide. So, the reception law of torts in India. Winfield proposed that every mental and psychical injury will considered as a tort unless justified, whereas Salmon that no mental and psychical injury can be said to be tort until or unless they justify the condition of pigeonhole. That's why the book explaining this concept of tort written by Winfield is called Law of Tort, whereas the book by Salmon is called Law of Torts. This concept has emerged in England, and the purpose of this law is to provide a remedy to the person whose rights has been violated. It is also the second hand of criminal justice by awarding exemplary damages. This concept has been a famous and secure place in the United States and the United Kingdom in many different countries, but still it is a growing branch of the tree and still developing in India. This tort is active in litigation, judiciary, and people. So we'll talk about the criticism. Pigeonhole theory has already been criticized. There are still many intelligent people and they are still questioning the future development in the study of law. In conclusion, I'd like to say that we can see that law of tort is not written anywhere. Tort law come under common law. As we can say, tort is not codified. Sometimes court needs to think with time and emerging new concerns. That's why both theory have equal role addressing torts, as it is a still growing area of law which is given by Salmon and Winfield. In conclusion, though the pigeonhole theory seems to be simple, the principle furthermore can also be functional in our everyday life, whether we realize it or not. That's it for today's video. Thank you for watching. If you guys have any questions regarding the video, please do ask in the comment section, and don't forget to like, share and subscribe the channel LEXCLIQ.